Ladies and gentlemen, good morning, good afternoon, or good evening. Wherever you are in the world, we appreciate you being with us right now. This is Lovely Life, a DOM podcast. DOM is a digital and bilingual media company specialized in law at the supranational level. So, for all news, comments, analysis related to law in Africa and in the rest of the world, go to our website, dom-online.com, and follow us on our social media platforms, the links of which are listed below. This, however, is neither a technical nor a political podcast. To be honest, sometimes it's barely a legal one. The only prerequisite needed is to have an open mind and 30 minutes or so to spare. We sometimes will have guests from everywhere around the world, and we will always be keen to hear your thoughts. We have a fantastic episode for you today, so please stay with us and weigh in while we argue the case. Lovely Life. Okay. In today's episode, we are talking about another fairly popular topic when looking at the intersection of law and life. Privacy. It is a term that is used fairly liberally, especially since the age of social media, without always fully appreciating its contour. So, on to our disclaimer for the day. Legally speaking, it is a massive topic that touches almost every area of law, from non-disclosure agreements in contract law to protection of data, and even whistleblowing. There is a lot to be said, and it is impossible to even cover a decent amount of the ground we would need to cover from a legal perspective in just 30 minutes. Whenever this happens, one of the easiest ways to deal with the abundance of information is to pick an angle and explore the concept through that prism. In this particular case, we are going to look into privacy through the lenses of responsibility. You are going to see what I mean in a moment. By the way, if there is one notion that you would like to be explored more in depth, privacy in contract law, tort law, competition law, constitutional law, certainly international law, just let me know, and we will have a special episode dedicated to it with a case study to boot. Now, let's properly start looking at the notion of privacy in a legal sense and, as usual, frame the issue. The right to privacy is recognized at the international level, as indeed, international human rights law provides a clear and universal framework for it. It is enshrined in various international instruments, such as the Universal Declaration of Human Rights, Article 12, the International Covenant on Civil and Political Rights, Article 17, the European Convention for the Protection of Human Rights and Fundamental Freedoms, Article 8, the American Convention on Human Rights, Article 11, or the Cairo Declaration on Human Rights in Islam, Article 18, among various others that can obviously be found on the treaty section of our website on dom-online.com. It is interesting to note that although it is a fundamental right at the international level, it is not always protected as a constitutional one, depending on the country. Let me explain, because if you don't know how international law works, it may be a bit confusing. You know how I always say that not all rights are made equal? Last week, in our previous podcast, we talked about freedom of expression. And I said that the right to free speech and the right to have an opinion sat at the very top of the pyramid, so to speak, of protected rights. Well, it is because those are not only considered as fundamental human rights in international law, but they are also constitutionally protected almost everywhere around the world. And of course, the Constitution is the highest law of every land. To disregard such rights entails the sharpest of legal consequences. And it is not necessarily the case for the right to privacy. Here, I'm going to be schematic, because there are nuances that should be highlighted, but that may either confuse or bore you. So I won't chance it. Every state is supposed to be sovereign, right? I think we agree on that. Because every state is sovereign, that means that every state gets to decide which treaty or convention it wants to sign and or ratify, and then how and when to incorporate the obligation taken at the international level into their legal system. It is in fact more complicated than that, but let's roll with that for now. So, the rights and duties that exist at the international level can be granted legal status. Understand here that they are protected by a piece of legislation, a law, a decree, whatever, or constitutional status. Understand here that they are protected by the constitution in each country. Does it make sense so far? Interestingly, the right to privacy is not recognized as a constitutional right everywhere. Indeed, Supreme Courts sometimes have to construe the relevant constitution quite extensively to find a right to privacy, and it is worth mentioning because one could make the argument that this has an implication on the responsibility attached to it. Now that we have set very roughly some legal parameters, we can begin to look at instances where one has a responsibility to use and or protect the right to privacy. The most obvious actor in this is oneself, you and me. This is especially true in the context of social media, where we are encouraged, or at least offered, the option to share across all sorts of platforms a little part of ourselves, be it thoughts, photos, videos, etc., etc. Setting up an account takes seconds, and there you are, with a potential global audience. But there's always that step, isn't there? When one is asked to agree to the terms and conditions of the platform after having read it, of course. And of course, no one actually reads them. Which is a shame, really, because by clicking on the I agree button, you enter into an agreement with the owner of the platform. Usually, such agreement contains important provisions pertaining to the right of privacy and the use of the data you have willingly put out there, including and up to the partners with which the platforms can share your information, and how long they will keep it stored. In such an instance, the responsibility to protect your data falls first and foremost on yourself. You are mostly the one who decides what is in your account. And I say mostly because we must always make allowance for the option of someone being hacked, for example. The consequences of posts made in the virtual world can be very tangible in the physical one, and can range from quote-unquote minimal embarrassment because of a picture posted years ago that you have completely forgotten, to loss of professional opportunities because the human resources of your company has done a deep dive on your activity online, or even be deplatformed, demonetized, or flagged. All of this is very basic, and honestly, I'm only mentioning it because we need to always remember that everything we post leaves a trail. Let's all be careful and take accountability for our actions. But we will come to the data we put out there later in the episode. Another question we need to look into when discussing the right to privacy and responsibility is that of the freedom of press. It is often said that in a functioning country, media are the fourth power, as their role is crucial in exposing and or sometimes even preventing injustice or unlawful behavior. Indeed, the media have to inform the public at large of the latest developments in any given subject that could be of interest to it. In order to successfully carry out that mission, they need to have a certain leeway in the way they work, as obviously no wrongdoer will be forthcoming. So, in a way, the whole legislation regarding freedom of press can be thought of as an exception, though narrowly construed, to the right of privacy enjoyed by legal and natural persons. This is mainly done by the use of quote-unquote sources that are legally allowed to remain anonymous. This protection, in most societies, is strongly upheld. One needs nothing less than a decision of justice to have that virtual seal broken. This, I believe, everyone understands and would be on board with when the activity reported on is criminal or unlawful. We tend not to feel sorry for the person whose right to privacy has been breached because he or she is suspected to have committed a felony, such as insider trading, money laundering, etc., etc. Anything you can think of. Of course, the use of anonymous sources also happen for way less important reasons, even trivial ones. For example, because we, in the general public, we want to know and indeed feel that we are entitled to know everything about anyone that is in the public sphere. And because information is an industry like any other, media outlets feel the pressure to deliver as the offer must meet the demand. The problem, of course, is that in doing so, media and we, public, we disregard the right to privacy to these people, who, yes, through their work, and perhaps will, are in the public eye. I know people rationalize it by saying that it is the price you pay for fame. And perhaps it is so, but come on. Would you want everyone to know everything about you? Would you want to ask yourself every day, wait, how do they know this about me? The question can be asked whether the infringement on the right to privacy that was deemed necessary and legitimate in order to expose and or report unlawful or unjust behavior has not been stretched a bit much when it comes to quote-unquote celebrities. The question is all the more important when media obtain their information through other means than relying on their sources. There are quote-unquote bombshells or quote-unquote leaks of highly sensitive and privileged information that were made possible by tapping phones, hiring private detectives, bugging cars, hacking emails. Really egregious and borderline criminal conduct, which goes beyond any exception provided by law to the right of privacy. If and when these behaviors are proven, the editor of the newspaper or the legal person responsible for the publication of these pieces containing the problematic information will be held liable. We cannot talk about this topic without mentioning the case of the News International phone hacking scandal. Here is a brief summary. The controversy involved the now defunct News of the World newspaper and other British media owned by Rupert Murdoch. Employees of the newspaper were accused of engaging in phone hacking, police bribery, and exercising improper influence in the pursuit of stories. The hacking was not only reserved to public figures and celebrities. Shockingly, families of deceased British soldiers were also hacked. The consequences of the scandal were twofold. From the point of view of the general public, there was a complete outrage. See, for as much as we can be curious and even nosy, most people live their lives upholding certain standards and naturally rebel against uncouthness. Most of the management of the group resigned immediately, followed by the Commissioner of the London's Metropolitan Police, as well as Dojon Chief Executive. Advertisers boycotted the newspaper, which ultimately led to the closure of the News of the World after 168 years of publication. That was the immediate aftermath of the scandal. I don't know if you have noticed. The second wave after public indignation is usually a legal one. This time was no exception. On July 2011, the then UK Prime Minister David Cameron announced a public inquiry that would look into the events and more broadly the wider culture and ethics of the British newspaper industry. This was the Leveson Inquiry, named after its chairman, Lord Justice Leveson. The inquiry lasted several months with 3 different modules, each of which informed by depositions of scores of witnesses. The first module dealt with the relationship between press and public. The second one looked at the interaction between press and police. And the third and last one addressed the relationship between press and politicians. The final report was issued on November 29, 2012, and found that the existing Press Complaint Commission was not sufficient and recommended a new independent body which would have a range of sanctions available to it, including fines and direction of the prominence of apologies and corrections. Leveson also made recommendations regarding the Data Protection Act, the powers and duties of the Information Commissioner, and about conduct of relations between the press, the police, and the politicians. Some aspects of the reports were implemented and others completely ignored. We are almost a decade later, and we would like to think that the press has learned its lesson, hoping that they continue to receive information through legal means. However, in a fantastic news, a group of high-profile persons, among which Elton John and his husband, Sadie Frost, Elizabeth Early, and others, have filed separate lawsuits on October 6, 2022, before the London's High Court against Associated Newspaper Limited for gross breaches of privacy, affirming that, quote, they have become aware of compelling and highly distressing evidence that they have been the victims of abhorrent criminal activity, end of quote, and including the tapping of homes and phones, the hacking of devices, or the impersonation of people to gain access to privileged and sensitive information. Now, in a statement released by the ALN, the Associated Newspaper Limited, the spokesperson stated that, quote, we utterly and unambiguously refute these preposterous smears which appear to be nothing more than a pre-planned and orchestrated attempt to drag the Mail titles into the phone hacking scandal concerning articles up to 30 years ago. End of quote. So, this is where we are at the time of this recording. This is a very live issue that should be followed closely because of the potential legal ramification to the never-ending tension between right to privacy and right to information. Okay, so far we have talked about the protection of the right to privacy and the responsibility attached to it from an individual point of view. Now, let's take a macro approach, as indeed we would be remiss not to do so. Because after all, we are living in an interconnected world and with interwoven economies, spearheaded by giant companies that store all our data and information. Remember the ones we talked about at the very beginning of this program? The ones I urge you to pay attention to. Yes, that information. In that regard, there is not a one-fits-all answer. States adopt their own legislation. Sometimes it is an implementation of a regional or international instrument. Sometimes it's not. It must be said that the European Union has the most protective regulation in the world when it comes to the storage and use of personal data. But, as we have already pointed out, digital economies are growing from year to year and driven by giant companies. In that context, the question of the transfer of personal data is paramount. A seminal case was that of Maximilian Schrems, an Austrian citizen who called for the Irish Data Protection Commissioner to invalidate the standard contractual clauses for Facebook use of transferring personal data to its headquarters in the US. The argument was that said personal data both in transit to and when stored in the United States, could be accessed by U.S. intelligence agencies, which, according to Mr. Schrems, was a violation of the General Data Protection Regulation, GDPR, and more broadly, the European Union law. The main rule in the GDPR is that transfers outside of the European Union and the European Economic Area are prohibited unless an adequate safeguard can be used. Mr. Schrems argued that there was no such safeguard in the US legislation. After years of legal battle, the matter reached the Court of Justice of the European Union, twice actually. But the latest decision was issued on July 16, 2020. In essence, the court pointed to the far-reaching possibilities of surveillance that exist under U.S. national security laws, mainly the U.S. Foreign Intelligence Surveillance Act, the Executive Order, and Presidential Policy Directive. These laws regulate U.S. authorities' access and use of personal data imported from the EU into the US, and do not have the control to adequately protect EU data subjects that may become the target of national security investigations. As was the case at the time of the issuance of the decision, the US public authorities could access the data without this being limited to what is strictly necessary. This US regulation does not provide, quote, guarantees for potentially targeted non-US persons, or rights enforceable against US authorities in court, end of quote. The court also found that companies must ensure that the recipient country has equivalent data protection to that of the EU. They cannot rely on the standard contractual clauses alone anymore. A company that makes data available for potential cross-border transfer, including common cases when using a non-EU supplier, shall inform themselves and assess the recipient's country level of compliance with the GDPR. The reception of the court decision was, as most things in life these days, a fairly polarized one. Activists for individual rights were delighted. Facebook promised to do everything possible so that, quote, its client, advertisers, and partners could continue to enjoy its services while protecting their personal data, end of quote. Make of that what you will, people. The US government issued a communication stating, quote, disappointment at the decision, end of quote, but vowed to continue to work with the EU Commission to come up with concrete next steps. That was the situation until October 7, 2022, when the US President Joe Biden signed an executive decree aiming at reassuring its European counterparts about the invasion of privacy and the storage and use of personal data from EU nationals or residents. In a nutshell, the text provides additional safeguards to ensure that access by US intelligence agencies, in the name of national security, to data collected in Europe and transferred or hosted across the Atlantic is limited to what is, quote, necessary and proportionate, end of quote. Above all, it opens the possibility for European nationals to act if they believe that their personal data has been illegally collected by US intelligence agencies and to obtain its deletion or correction if necessary. There are two levels of appeals. One to a civil liberties officer at the US Intelligence Directorate, and, in case of contestation of this decision, it would be possible to seize an independent court. The ball is now in the corner of the EU Commission to start a process to finalize the new regulation for the EU-US transfer of data and protection of privacy on the basis of this new decree. That is, of course, if Mr. Schrems does not file another application before the courts and challenge everything once more. We will have to wait and see. I have a feeling, though, that we won't have to wait long. Thank you so much for being with us today. I want to hear what you have to say. Do you have any comments, question? Does it make sense? Does it not? Leave a comment below the link of the episode on our social media platforms using the hashtag LoviLife. The transcript of the program will be available on Dome's website in both French and English. If you have enjoyed this episode, please consider sharing, liking it, and subscribing to the show. We have had some great episodes previously, and we would be very grateful if you would consider listening to them. We will be back with our next episode next Wednesday. In the meantime, please stay safe and take care of yourself.